So we're just here to talk today about Mainzeal and the reckless trading claim brought by the liquidators of Mainzeal and the recent decision that was made and to talk about the appeal.
So just a very brief background of Mainzeal. So Mainzeal had been around for back from the 60s. 1995 it was taken over by Richard Yan related interests, and it collapsed in 2013 owing $110 million. And the key issue, and those directors included Dame Jenny Shipley, Richard Yan, and two others, Mr. Goldman, Mr. Tilby. They were sued by the liquidators of Mainzeal for breaching their duties. And the key issue raised by the liquidators was that early on in the life of Mainzeal, between 2004 and 2009, around $40 million was taken out from Mainzeal and sent over into Richard Yan related entities, ended up in China. And one of the issues raised by the liquidators was that sucking out of money that was ultimately non-repayable resulted in the failure of Mainzeal, and the judge and the liquidators wanted to hold the company directors liable for that. And how did that case go, Brent?
Yes, I mean the board of directors did nothing adequate to ensure that the legal arrangements in relation to those intercompany loans were well documented, which was one of their crucial failures. And so here you had a case where liquidators pursued 12 causes of action against directors. One of them was successful. Reckless trading, so they got a judgment for $36 million. Now to put that into context, you have creditors of $110 million, $45 million owed to subbies, $9 million owed, so $12 million owed to employees, and so in the context of that massive failure, you have a $36 million judgment. So in my view, I mean, it's woefully inadequate.
Although part of the reason why, so there's two essential causes of action. There's 135, which is reckless trading, which the judge did find against the directors. Although it was a fairly close run thing, because the judge says before he could find for them, he had three questions. Was the company balance sheet insolvent in account of the work of the intercompany loans? Did the company have financial support ultimately from the group? And the answer was no. And was the company trading profitably? And there the answer was no. But if any of those three had been tipped the other way, then the judge would not have found even a 135 case. And he said in the judgment it was a close run thing, because had he been convinced that the directors had confidence in group support, he wouldn't even have found a 135. But you've got some pretty strong views on 136. Now, so 135 is reckless trading. 136 is trading a company, incurring an obligation that you as a director do not have reasonable grounds to believe that the company can pay. Now, in that situation, the judge found against the liquidators in favour of the directors. But you've got some pretty strong views on that.
Yeah, well, I mean, reading the judgment, it's pretty clear that the liquidators, they ran their 136 case rather poorly. So they didn't plead it properly. It was left in a situation where there was no specifics of the allegations, and so the directors didn't put in their evidence, the necessary replies to a 136, because it wasn't pled, and as a result, you've got a situation where they haven't been cross-examined on all of those issues. The evidence is not available, and so the judge couldn't have made a decision against them anyway.
Even if he had thought. So what you're saying is that that specific allegation. So the allegation was, as the director of Mainzeal, they went ahead and they agreed to do all of this work on the project. All of the creditors on that project ended up being owed money by Mainzeal. So that was an obligation that was incurred by Mainzeal, and the liquidators said the directors had no reasonable expectation that Mainzeal should be able to meet those obligations. But what you're saying, and what the judgment appears to say, is that the liquidators did not specifically put in evidence the details of those contracts, and because of that, the judge is saying that the directors didn't have the opportunity to respond. So he's not saying that they weren't guilty of 136. He's just saying that the way it was pleaded, he didn't have the opportunity to find for it.
Well, yeah, I mean, so we've created a video which goes into all of that detail that will discuss what all the details around the case, how the liquidators ran the case, the defendant's case.
It's a great video.
It will talk to
goes for 44 minutes.
Yeah, it will talk to the likely recoveries and what creditors could expect once this washes through the Court of Appeal and probably the Supreme Court, which is, in my view, not a lot.
And of course, it would be ideal if it did go to the Supreme Court, because Mainzeal built the Supreme Court building. So that would be excellent. And those hot takes and more are in the 44-minute video for those of you who want to stick through that.
I hear the after party is at Spark Arena, which they also built.
It's a good video.
All right.
Thank you, guys.